All right, folks, we're going to get started. We had several others that had registered for this lunch and learn. We will get started. I want to be mindful of everyone's time, and we'll just admit those that come along the way as we go along. So I'd like to welcome everyone to the call today. Vanguard, we have started this lunch and learn series prior to the pandemic. We actually were doing them in our office, and obviously since that is not a conducive format anymore to what's going on in our world, we started these about 4 weeks ago virtually. So our goal with the Vanguard Lunch and Learns is in a 45-minute session to provide some really granular and relevant content that we feel is coming from the questions we're being asked by our clients and things that are relative to what's going on in the current climate. Our next 2 weeks, next week, we will be hosting Jane Brody from Vicus Partners, and Jane will be speaking about a return to workplace strategy, and it will be regarding setting up your physical location and the best way to do so in light of return to work from COVID-19 crisis. And then after that, we will be hosting Jim McTighe from Mass Mutual, and his topic will be Social Security. So those are the next two topics. We plan to have these on a bi-weekly basis. However, we may slide one in week to week if we feel like the content is necessary. So that's why we're having the return to workplace strategy next week in consecutive weeks. I do want to mention one thing for our clients that are on this webinar. We do have some exciting news we will be sharing with you in the near future. We have contracted with an organization called EASE to provide technology to our clients, specifically benefit administration communication, where we'll be able to interact with you and your employees and provide mobile apps and allow for more efficient open enrollment. So stay tuned, more information on that. We plan to be reaching out at least on your next open enrollment. But if you have questions and you want to discuss this in the meantime, please feel free to reach out to us. I do want to introduce Darren Tiso. Darren is from Ameriflex, and Ameriflex is one of our partners that we utilize to provide flex spending accounts and health reimbursement arrangements, HSA, high deductible accounts for our clients. So welcome, Darren. Darren has some very insightful information regarding our topic today. So I asked him to join and thought it would be great to have him weigh in as we go along. And lastly, I just want to make sure that this is an interactive chat. We are going to go through a lot of information. This is something that I believe is really relevant, as we've been getting a lot of questions on this topic recently. So we will make it interactive. If you have questions as we go along, you can put them in the chat, and we'll try to stop along the way to see if there's any questions. And at the end, we'll go through a formal Q&A. And like I said, we'll wrap this up no later than 12:45 so we can get you on with your day. And of course, we are recording this. So we will be sending out the full recording of this presentation along with the slides after we're finished with the presentation. We'll have that out this week. So with that, I'd like to get started. So we're really going to be talking about 4 recent pieces of regulatory action, and they were released by the IRS and the Department of Labor. And the 4 pieces of regulatory action we're going to talk about are the extension of certain timeframes that affects employee benefit plans and the participants. EBSA released a disaster relief notice that we'll talk about. And of course, COVID-19 had guidance on cafeteria plans related to high deductible plans, and what is permissible under Section 125 as far as modifications. So we'll touch all of these subjects along the way. This was the government response, or part of the government response anyway, to the COVID-19 crisis. And as I said, these both touch the IRS and the Department of Labor. And we've been getting a lot of questions on this, so I believe it's a very relevant topic. So first, what we'll talk about is the extension of timeframes. And a few things to note here. The extensions of timeframes, of certain timeframes, was very specific in their guidance as to what it relates to. And it is focused on HIPAA special open enrollment periods, COBRA, and claims procedures, and particularly external reviews. You're going to hear some new language, and what we're going to refer to a lot in this presentation is what's called the outbreak period. So the outbreak period is really a term that was made up by the regulatory agencies. This is a new term, was not relevant to anything before the COVID-19 crisis. So you're going to hear us talk about as we go along that the outbreak period is very relevant to a lot of the timeframes that have been extended. So when the outbreak period began on March 1st, 2020, and technically the outbreak period ends at the end of the national emergency. So obviously the national emergency has not ended as of yet, but it ends 60 days after we declare that President Trump declares that the national emergency is over. So in general, as we talk about some of these related regulations, the outbreak period is disregarded. And what that basically means is some of the timeframes that are associated with COBRA and some of the other regulations we discussed are actually frozen in time during the outbreak period. And that's really what we're going to get more involved in. It's just that those times are suspended. So you will see that those timeframes, whether it be the COBRA period, election period of 60 days, if you were in the middle of that, that actually is frozen until the end of the outbreak period. We'll get more in detail about that as we go along. You know, some of the issues that we have are we really have no idea when this outbreak period is going to end. And you will see as we go through this presentation how that will be impactful to employers that might have some decisions to make that will be difficult because we don't know when it's going to end. And it also could vary depending on the region we're in. So depending on how COVID-19 spikes or is under control in certain areas might determine the end of the outbreak period in certain areas and not others. So I think that that's important to note. Darren, just feel free to jump in anything. If you have any comments on what we've talked about before or as we go along, feel free to jump in along the way.
Will do.
So to talk about the extension of certain timeframes. So what's extended? Well, one is the HIPAA special open enrollment right, which allows employees to change their elections or enroll upon the loss of coverage or addition of a new dependent, or if they want to enroll a Medicaid or CHIP program. This is normally about a 30 or 60 day period. So what this basically means is if you had an enrollment, let's say for instance, you had an employee whose spouse was married and they were recently married, had their spouse, wanted to add their spouse to the plan. Typically, they would have 30 days from the date to enroll that dependent. That is going to be impacted by this because now that would be 30 days from the end of the outbreak period that they would have to supply that. Now, as we go along the way, some of the other things that we have to consider here is what is your insurance company allowing as part of this. But you will see that they have the right to 30 days to enroll in coverage under the HIPAA special open enrollment period from the end of the outbreak period. This also impacts claims. So the standard time frame for claim submissions could be typically 180 days from the time of the date of service. This will be impacted as well by the end of the outbreak period. So if you were in the middle of a claim, you could technically have up to 180 days from the end of the outbreak period to submit that claim to your carrier, and as well as the external review period and the time frame to fine-tune that review will also be impacted by that. So there will be added time to claims filing for external review periods if the employee decides that they want an external review of their claim, and also time to perfect that will also be impacted by the outbreak period. So they will have an extended period of time to submit those claims. Talking more about a claim submission. So we talked about deadlines for claims that are being submitted, and we're generally impacting plans that are subject to ERISA, which are in the private sector. But ERISA really doesn't set the time frames as to when claims are filed from an impact of FSAs and HRAs. That's really more of an employer decision on that. Typically, it's 60 or 90 days, but ERISA is not really addressing that when it comes to FSA and HRA and the run-out periods, right? So the run-out periods are going to be the time frames that you have after the end of the plan year for employees to submit claims for the prior year. So that will be impacted by this as well, and could be significantly. So from an impact of a calendar year plan, so if you're on a calendar year plan on an FSA or an HRA with a 90-day run-out period, that run-out period could be suspended on March 1st. So if it was a 90-day period, the employees would have 30 days more to submit claims from the end of the outbreak period. So technically, if you had a calendar year plan, the plan year ended on 12/31 with a 90-day run-out period. Your employees and your employees at the onset of the outbreak period was March 1st. Your employees would have had 30 more days to submit that claim under normal circumstances. So now they will have the end of the outbreak period to do so on your FSA plan. So if that end of the outbreak period, let's say, is January 1st, 2021, they would be able to submit claims up to the end of January for the 2019 plan year. Darren, I know this is something that you've been dealing with a lot. Any comments there that you'd like to make in regards on how Ameriflex is handling this?
Yeah, I mean, you've got the information correct. I would say that the dependent care FSA and commuter benefits are not subject to ERISA, so this would only apply to the medical FSA and the HRA. Great.
Yeah, that's a great point. It does apply to FSA and HRA, so dependent care typically has a lot more flexibility because it's not subject to ERISA throughout the year anyway, and that, so it won't be, this rule will not impact that as much as it does on FSA, but that's an important point to note, so thank you for that. One thing we should note also is that if there's any claims that were denied in that period because they had exceeded the run-out period. So for instance, let's say you chose a 30-day run-out period for a calendar plan year, and the employee tried to submit a claim in February for that time period that was denied. You may have to go back and discuss that with the employee and have them resubmit that claim, because they would now, under this new guidance, be eligible for submission. So keep that in mind, that you may have to look back at those claims that might have been denied already.
Also, filing an appeal has been extended as well.
Correct. Any questions? I'll stop there for a moment. Any questions on there? Because we're going to move on to another component here. Okay, great. So let's talk about COBRA. And I think COBRA is something that creates a lot of challenge for particularly for employers, but more so just a lot of decisions that need to be made. You know, we found that COBRA has been big throughout this crisis because employers were furloughing employees, and they needed to make decisions on benefit plans as to whether they were going to keep them on benefits or they were going to terminate their benefit plans and offer COBRA. Some employers decided to do that. Some employers paid for the COBRA. Some employers kept employees on benefits throughout while they were furloughed until they brought them back. And now these COBRA timeframes have been affected and impacted by this. So all of the normal guidelines for COBRA and the normal timeframes have now all been added to the outbreak period. So for instance, the timeframe of a qualified beneficiary to notify a plan of a qualifying event such as a divorce was normally 30 days. Now that would be 30 days from the end of the outbreak period. The deadline to provide a COBRA election notice by the plan administrator to an employee is typically 14 days. That would now be 14 days to the end of the outbreak period. Now, the COBRA election period, which will create some challenges here, is one of the big ones. So typically an employee would have 60 days from the date they receive the COBRA notice to elect COBRA. And that now, in fact, will be 60 days from the end of the outbreak period. So employees' outbreak period, COBRA election period, could now be extended by as much as a year or more on this, depending on when that outbreak period ends. And I think a lot of employers are gonna have to look at this because there may be employees that they put on COBRA during the outbreak period because they furloughed them. And if they didn't bring them back, they may have situations where employees are eligible to go back for the length of this outbreak period. So something that definitely should be looked at. The deadline for first premium and premiums, we're going to talk more about this as well. But typically for somebody that elects COBRA, they have 45 days from the election period, from the date of the election to make their first period. That would be extended to the end of the outbreak period. The grace period for routine payments. So if you have employees that are on COBRA already and are making monthly payments, they typically get a 30-day grace period to make that payment. They would now have 30 days from the end of the outbreak to make that period, that payment. So something there to be considered. And then, of course, the deadline for qualified notification of second plan. So if you had, COBRA is 18 months, and if you had an employee that became disabled and would qualify for a second election period for an additional 18 months because they were disabled, they will also have that time period after the outbreak period to elect that second decision. So just a lot of the different choices that employees and employers are going to have to make under COBRA, it's really going to have to be looked at from the standpoint of how long it's extended. Just to give a couple examples, and I think that these are pretty basic examples, but if you look at the first one, an employee was terminated on March 30th. The COBRA election notice was sent on April 7th. The employee and the dependents will have until 60 days after the outbreak period. Because that initial COBRA notice was in the middle of the outbreak period, they will have 60 days until the end of the outbreak period in order to make that election. Now, something that we referenced earlier about the outbreak period actually being like a period in time that's frozen, if that situation were prior to March 1st, and let's say that COBRA election period started on February 1st, well then they would have had the 29 days that were in February against their COBRA 60-day election period, which would have left them 31 days, which means they will have 31 days from the end of the outbreak period to make that COBRA election. So it's frozen in time as to where they were at the beginning of the outbreak period. Second example we're showing here is the COBRA election period, COBRA election period on April 15th without the initial premium. So the qualified beneficiary has 45 days to make that initial premium for COBRA, and they will now have 45 days from the end of the outbreak period, because that April 15th, of course, is in the middle of the outbreak period, to make that first initial payment. And then the last one, COBRA coverage started in 2019. They had been paying premiums for April and May, which fall within the outbreak period. They will have 30 days to make that payment as a grace period, but that will be 30 days from the end of the outbreak period, because that time frame was in the middle of it. So there's definitely going to be some issues created by COBRA, as we started to allude to. Notice obligations are one. So as employers are, whether if your employers are doing this on their own, or whether they're using a third-party administrator like an Ameriflex to use to send their COBRA notices out, those notices are probably going to have to be, now there's no specific guidance on this, but they're probably going to have to be updated with the new timeframes in those notices. So you want to take a look at what notices you're sending out to employees, and what that length of time says, because if it says 60-day election period and it doesn't say from the end of the outbreak period, and that notice went out during the outbreak period, that could be out of compliance.
Yeah, just how Ameriflex handled this is, once the new regulations came out, we sent a second letter that was crafted by our ERISA attorney to all of our qualified beneficiaries that were terminated March 1st or later. Going forward, what we've done is we're sending out our standard COBRA notice, which is required by the DOL, and we're adding a second page that explains the extended rights during the outbreak period.
Excellent. And again, if you're using a third-party administrator for your COBRA administration, this is probably being addressed by them in most cases. If you're in a situation that you're doing it on your own, you should take a look at this and make sure that your language reads correctly in your notices. The other challenge that which could be a big one is that qualified beneficiaries can have till the end of the outbreak period to elect COBRA. However, they're going to be responsible for the premiums. Let's remember, COBRA is retroactive to the termination date. So if that premium, that initial termination date was on March 31st, which made their election notice April 1st, and they do not elect COBRA, but decide that they will elect COBRA in January of 2021, they're going to have to go back and pay all the premiums for the months that get them back to that retroactivity of April 1st. So that's going to create a big invoice for an employee, depending on what the premiums were, of course. But in most cases, that's going to be a big bill. And can people really afford that if they're banking on utilizing that time period? That all remains to be seen. How coverage is handled during this period is really a big issue here. And so with COBRA, as you may or may not know already, you have the ability to either suspend coverage if a payment is not made by the first of the month, if they've already made their initial payment, or you can retroactively terminate. So what that means is if your premium was due on July 1st, as an employer, you can terminate them on July 1st, and if you get the payment on July 15th, you can then add them back to coverage. But if you also have the ability to allow them to stay on the plan until the end of the grace period, and then retroactively terminate them, which carriers are all they all support that model, whichever way the employer decides to go. That language also may have to be changed within your COBRA notice, because it specifically says you will or will not suspend coverage during the grace periods on a normal basis. But now the thing is, if your COBRA notice says that you will not suspend COBRA coverage during the grace period, and that grace period is now extended out to the end of the outbreak period, you might be in a situation where you have to continue that coverage, which means that the the carrier will be billing you for that coverage until the end of the outbreak period. So just make sure you're looking at the language in the letters you're sending out. My thought would be that most employers will change that to that they will not allow coverage to continue after the grace period. The problem with that is we're not sure how the carriers, and they have not really given any response to how they will react to that. So if you have an employee that comes back in January of 2021 that you've had on suspension, but they are within their COBRA election period still because of the outbreak, and you decide you want to retroactively enroll them back to the effective date, the carriers have not given us any response yet as to whether they will allow that. So more to come on that, but something that definitely should be considered. And this does apply to all plans that are subject to COBRA, which includes FSAs and HRAs. Now, we don't really see that too often, that employees elect COBRA for HRAs and FSAs, but it does apply to them, so just be aware of that. And I'll stop right there because I think that's our last COBRA slide, to see if, Darren, if you have any other comments to this or if anybody has any questions.
Sure, Ed. Also, if let's say an employee was terminated in May, they had a medical procedure in June, and they waited to 60 days after the outbreak period to re-enroll, and then they had 45 days to make a payment, they could retroactively just enroll for May and June. They wouldn't have to make the payments for the whole time period.
Great point. Right. So all they're required to do is go back to the retroactive termination date, and then they can decide that how many months of coverage they want to pay from there. So that's a good point. Okay, so if there's no questions, let's talk about how this impacts the EPSA notice regarding other ERISA documents, and it does apply. So for some summary of summary plan descriptions, summaries of material modifications, and notice of adverse selections on claims, this also has been applied to the end of the outbreak period. So typically on a summary plan description, it must be provided to the employee within 90 days. And that is now going to be affected by this as well to the end of the outbreak period. So it will give some flexibility to employers to extend that period out. They don't give, actually, let me back up for a second, because what they're basically saying is they're mentioning the end of the outbreak period. However, the plan administrator, what they're asking them to do is act in good faith and basically provide this as soon as they possibly can or as practically necessary under the circumstances. So if you're you're an employer and you're in a situation where your business has been impacted by COVID-19, maybe you can't have access to your office or circumstance like that, and it's not practically possible to get that summary plan description out to the employees, you will have time to do so, but they do expect you to do it in good faith and when practically available to do so. Also, they're encouraging the use of electronic alternative means of communication for this. So they have, the DOL and the IRS has both said that it's perfectly acceptable to make these notifications under electronic means, and they're encouraging, if that will speed up the process especially, to go ahead and do so. Okay, so let's talk about Section 125 cafeteria plans and how the guidance from the DOL, from the IRS, impacts this. One thing to note, this is of everything we talked about here, this is all temporary, and should be noted that it's only available through the end of 2020 as we speak. Okay, so this is a temporary rule that was put in place, and the reason why it was done is the current regulations under cafeteria plans and rules didn't fit well with what was going on with the COVID-19 crisis, and the fact that many employees were furloughed, many employees were terminated, many jobs were disrupted, salaries were interrupted. So there was a lot going on that employees needed some flexibility. And so the IRS recognized this and did come out with guidance on this to allow some flexibility, specifically because of COVID-19. And again, these rules are normally, under normal circumstances, when you make an election under a cafeteria plan, it's an irrevocable election until the open enrollment period, and this allows for a temporary suspension of that regulation, which would allow for election changes. They are optional, so this allows an employer to do it, but the employer does not have to make these changes under their current plan. So that's important to note. But if they do make the change, you should make sure that if you check your plan documents, your summary plan descriptions, and your plan documents to make sure that what you're communicating is consistent with what's in the language of your documents, and that you do make good communication to your employees, and it's uniform throughout, to make sure that everybody understands exactly what your intentions are to allow for mid-year election changes, and most importantly, that it doesn't benefit one particular class, one particular type of employee and not another. So let's talk about the exceptions. And again, I'll remind everyone that this is the employer's choice. So, but this is what would be allowable. And there are 5 new exceptions that have been created. 3 of them, the top 3, pertain particularly to health insurance plans that employers offer. And the last 2 would be more relevant to flex spending and dependent care FSAs. And so, as I said, it's the employer's choice here. So the first exception would be for new elections or enrollments. So it does allow for an employee that had previously waived coverage for an employer-sponsored plan to allow for them to make an election in mid-year through the end of this year. It also allows for a change under the pre-tax regs. So an employee that was on a higher option plan that could no longer afford it, or a lower option plan that maybe is going through some health issues and wanted to take a better plan during that period, they would be allowed to do so under this new guidance. It's important to note also that these are prospective changes. So this does not mean that this would go back to the beginning of the outbreak period. This would impact on the next available effective date, or within the 30-day rules of when you're allowed to, under normal circumstances, to make these new elections. They would be allowed under that circumstance, but it's prospective going forward. So my point is, you can't go back and make, if your open enrollment was January 1st and you want now in July, you decide that you need to change your plan, you can do so, but it will not go back to January 1st. And then, of course, the third reason is if you want to stop a pre-tax deduction. So if you want to stop pre-tax deductions, like I said, maybe you're in a situation where your job has changed, you cannot afford the payroll deductions any longer. This will allow you to make a change, and you can stop that pre-tax election for health insurance during this time period. The 2 that apply to flex spending and dependent care really allows for a wide open prospective change. So you can really make some changes to this. As we mentioned before, dependent care had normal flexibilities because it's not subject to ERISA. And flexible spending accounts did not have much flexibility in making new elections, revoking, or anything. So again, with this, you can make a new election under FSA and change your election under a flex spending account, but this is also a prospective change. So this will not will not go back to the original election date. It will go on it will change your election on a go-forward basis. And again, this is to the end of the year. And the same thing goes for a dependent care reimbursement account. It will be a prospective basis and go from now until the end of the year. Darren, anything you want to add there?
Yes, just that the dependent care in particular has been a pain point for a lot of employees. Let's say somebody on January 1st made a dependent care election because they were planning to send their child to day camp. And now the day camps are either closed or they don't feel safe sending their child there. They can stop making elections into the dependent care account, but the contributions that have already been made are subject to the use it or lose it rule.
Got it. So that's a great point, and something we've had experience with already. But to basically what Darren's saying is that if you made an election, you've spent some of that money already, you cannot go back to the original effective date of the election, change that election, and take that money back. That money is already spent. And from a use it or lose it perspective, Darren, you cannot take back the money that's already been put into the account, even if it wasn't spent. Am I correct in that?
That is correct. Now, if an employer is sympathetic and is concerned that their employees are going to lose money because of that scenario, what they can do is let the plan year run out, let the run-out period run out. The account would go back to zero. It would show up as a forfeiture. That employer could, let's say it was $1,000 they lost, could give a bonus to that employee on a taxable basis for that amount.
Right. Yep. Great point. Something we dealt with just in the last 2 weeks for one of our clients, and that's exactly what they decided to do, was to wait till the end of the year. Again, 12/31 is the end of this this special exception period. So at the end of the year, you would be able to bonus that money. Oh, wrong way. Okay. So there is, for exceptions that are employer-sponsored group plans, what the IRS has only really made reference to group medical coverage. It does look as though it would apply to any group-sponsored plan that was covered under ERISA. However, there's no mention of dental or vision or any of these plans so far from what we've seen. So more to come on that. They have not really given any guidance. Darren, have you heard anything on that?
No, it's just health plans.
Yeah, that's okay. That's what we're hearing as well.
Which would, as you mentioned before, include FSAs and HRAs.
Correct. And again, talking about the flexibility, some of the flexibility, again, it's important to note, this is what the IRS is allowing, but not mandating. So employers have some flexibility. And, for instance, if they wanted to limit the FSA election only to increases in FSA election, they could do that. They could allow the employee to go from self-coverage to family, but not to drop family members. There's things that can be done that the employers can do. From what we're seeing so far, employers have been very flexible with this and have been accommodating to employees in a lot of these changes. So, but it's just good to know that there is flexibility in what the employer can do. We talked about FSAs limiting reductions to no less than what's already been reimbursed. And it's a prospective, even though the law reads it's retroactive to January 1st, it is a prospective view of when this is allowed. So if you made your election in February, you're allowed to change that election, and that technically means that you've changed your February election. However, it's prospective, it's not going back. And I think that's important for you to know, so because your employees are going to be asking those questions. And you want to definitely, during that period, if it was before this, you want to watch out for people who requested these kind of requests and were denied prior to these regulations coming out, and how to handle them. And again, that might be a situation where you want to go back to that employee and have a conversation with them, allowing them to make that change going forward. So the claims period for health FSAs and dependent care FSAs were affected by this as well. And so employees are now allowed to use those funds for a longer period under the grace period regs. So the grace period for a plan that was a non-calendar year plan, so this is what this really most affects than it does calendar year plans. But for a non-calendar year plan, your grace period, if you chose a grace period of 2.5 months for your plan, and your plan ended, let's say, during this time period, let's say it ended March 31st, which would typically give them 2.5 months from them. The guidelines say that now you have the grace period has been extended, and that extension is till 12/31. So if you have, under use it or lose it rules, if you have a healthcare FSA that has a 2.5 month extension that you've chose instead of the rollover in the past, you will now be allowed to have that period for the employee to extend to December 31st, 2020 to go back and use those funds. On a calendar year plan, this is not impactful because, again, it reset 12/31/2019, which is before this goes into effect, and it ends on 12/31/2020, which would be the same time period that the extension allows. So for those plans, this is really not impacted by that. And this is available to FSAs and limited purpose FSAs and dependent care FSAs as well. So talking about the claims, again, into the claims extension period, the thing to note here is that if you have chosen a rollover, the rollover in the past, that $500 rollover where the employer was allowing for an employee to roll over $500 into the next year, you now have the ability to allow your employees to take advantage of both. So if you had a $500 rollover plan, and that was a non-calendar year plan, and it was extended into this year, you can now allow that employee the $500 rollover, and you can add a grace period to that would extend through 12/31 of 2020. So that's important to note that now through the end of this year, an employee is going to be able to take care of both should you decide to allow them to do so. Darren, anything you want to comment on there? I think you're on mute.
Sorry, not on that specifically, but I would mention that in the CARES Act, a change that did come through was that for FSAs, HRAs, and HSAs, over-the-counter medication and female menstrual products are now eligible expenses. In the past, they were not. And this was particularly important because during the lockdown period, people were not able to go to the dentist, the optometrist, the doctors, unless it was an emergency. They had nowhere to spend their FSA dollars.
Yep, great info.
And that is a permanent change.
Okay, so just a couple of things to note with reference to that. Changes to elections require a plan amendment. So if you're going to allow your employees to make election changes, make sure that you amend the plan to do so. The IRS is giving employers till the end of December 31st, 2021 to make those plan amendments. So obviously giving plenty of time to make that plan amendment, but the changes must be uniformly administered, and they're asking that you communicate this effectively to your employees now, even though you actually haven't amended your plan documents. So just keep that in mind. Darren already mentioned this, but to talk about some of the changes with respect to high deductible plans, Darren referenced the menstrual products and over-the-counter medications, but the guidelines from the CARES Act also address high deductible plans and expenses related to diagnostic testing, as well as others for COVID-19, and that, of course, is all, and treatment for COVID-19 has all now been added to high deductible plans, and is allowable under law for reimbursement to employees under high deductible HSA type plans. And so it also allows for employees to receive telehealth during the crisis. Many, as Darren mentioned, many providers were not able to do in-person services, so you weren't able to do elective well visits, and you might not even been able to do even specialty visits, or certainly not elective surgeries for a long time. Many of these types of services, of course not surgeries, but many of these type of services were converted to remote healthcare and telehealth, and that was all added to the language under the CARES Act that specifically related to high deductible plans to allow for that to be reimbursable under those high deductible health insurance plans. So keep that in mind. And just want to touch briefly on the carryover election that we discussed a few moments ago. So until now, the carryover election for an employer was capped at $500. So employees would, if an employer allowed, employees would only be able to carry forward $500 towards the next year. And that was not indexed for inflation like normal max spending on the flex spending account rules are. So that has been changed under this guidance. And so now the amount of the rollover is specifically tied to the amount of the flex spending election, which is indexed for inflation. So that allowed the maximum increase to increase from $500 to $550. Okay, so the maximum carryover, like we said, it's set at 20% of the maximum election under the flex spending guidelines, which is $2,750. So that is now a carryover that started in $550 in 2020 at $550. I believe this is a permanent rule, but Darren, can you confirm that?
It is a permanent change.
Great. So yes, this is a permanent change. So going forward, your employees will get $550 if you allow it. They will get $550 ability for rollover, and that will be indexed as the index is increased for flex spending account maximum elections. You can have a lower maximum election if you like. So an employer does not have to go with the full $550. If you want to make your maximum rollover to $300, that's perfectly within your guidance. The other thing I will mention, I don't think I said this before, with respect to grace periods to the end of the year, employers have some say in that as well. So although the IRS is allowing for the grace period to be extended to December 31st, I believe employers have the ability to make that November if they'd like. Is that correct, Aaron?
That is correct.
Okay, great. So employers have some flexibility there as well. Again, we talked about this already, but there's going to be a need to review the document language, making sure that any of these amendments are consistent with the plan that is adopted. And just like the flexibility we talked about with changes to summary plan descriptions, these adoptions can be amended until 12/31 of 2021. Okay. With that, we'll stop there. We're a little over on time, so I appreciate your patience, but I think a lot of this was very, very relevant information, and we wanted to get it out there. We'll stop here for a few moments in case anybody has any questions. We're happy to take them right now. Okay. Regina, do you have a question? You might be on mute. I see your mouth moving, but I can't hear anything. How about now? No. If you have a question, you want to type it in the chat real quick, you can do that, and we'll address it. Okay, we have a few questions here in the chat. So we may have addressed this one, and I want to make sure. So Regina's question is, if it has to go back retroactively, can the employee decide how far back they want it to go? What are we referencing, Regina? Are we talking about COBRA? So I think I'll just address a few different scenarios. One, let's talk about COBRA. If we are talking about COBRA, as Darren said before, it can go back retroactively, but he brought up a great point before where it doesn't necessarily mean that they would have to pay the entire amount to get them through to where they were. It would go back retroactively to the COBRA election date. However, if they wanted to pay 2 or 3 months of that to get them through a hospital claim, let's say that came within the first 3 months or something like that, that's definitely within their rights to do so, and then they can terminate COBRA after that period. It's important to note, though, if an employee does do that, they lose their right to COBRA. So once they decide to terminate that plan, they would not be able to go back and elect it again. So if you wait until the end of the outbreak period and your election date was March 1st and you wanted to get yourself through to June 30th, you could certainly go back, pay those premiums to June 30th. Your termination date would be July 1st, but you could not come back in September or October and say, I want to go back on COBRA. So that's important to note that. As far as FSAs go, and pre-tax elections, again, they do go back retroactively. However, it's on a prospective basis. So that means from an FSA standpoint, you can go back and change your election. So if you made a $1,000 election for this year and you wanted to go back and change that, you can, but that does not mean that you can recoup the funds that were already spent or already payroll deducted. So keep that in mind. And I see now Regina was referring to COBRA, so I think we answered your question so far. So thank you for that. I'll just remind everybody, I see a couple of questions here. We will be sending out these slides, so everybody will get it. We will also send you a recording of this presentation. Any other questions? Okay, so I don't see any other questions. So with that, I would like to thank everybody for joining us today. Particularly, I'd like to thank Darren Tiso from Ameriflex for joining us today and adding his technical expertise. And I would say if anybody has any questions related to any of these matters, please feel free to reach out to us. We're happy to provide any guidance we can. And I'll just remind everybody to, in a lot of these, really, it makes a lot of sense to look back at your current plan documents and notices to make sure that your language is reflecting what you intend to do going forward for your employees. So with that, I will end the presentation and remind everybody that we will be back next Wednesday, the 29th. Our topic will be a return to work strategy, workplace strategy, and that will be presented by Jane Brody of Vicus Partners. So we look forward to seeing everyone next Wednesday. Have a great day. Look forward to seeing you all soon. Thank you.
Bye now.